Okay, this morning, Thursday, August 10th, Special Prosecutor Jack Smith filed a request it's a response to the court's August 3rd minute order. The court issued an order on August 3rd saying both sides get me your proposals for trial dates in the January 6th attempt to overturn the 2020 election indictment that's currently pending against Donald Trump, and only against Donald Trump so far. More names to come. So they filed this pleading this morning that Jack Smith wants the trial to start on January 2nd, 2024. So, 11 months before Election Day. He estimates the trial will take no longer than 4 to 6 weeks. And most importantly, a January 2nd trial date, Happy New Year, Donald, would vindicate the public's strong interest in a speedy trial. So I'll just show this to you guys. So it's different in state court or county courts when each side proposes this type of a trial date. In federal court, you also have to propose a calendar for dispositive motions, meaning like a motion for summary judgment that could get the case dismissed, other motions, and then as you get closer to trial, you have pretrial motions, which are called motions in limine. You get oppositions to those motions, replies to those motions. You set a date for a pretrial conference, and then they're proposing that jury selection in this case start on December 11th. So they're allotting 2 weeks for jury selection, because one of those weeks is, from Christmas to New Year's, and who wants to work during that week? Culminating with the trial starting on January 2nd. So that's the schedule and the calendar that Jack Smith and his folks are leaving out. Going on, it would provide roughly 5 months before the start of trial for defense to review discovery, which the government expects to be substantially complete in advance of the court's next hearing, which is on August 28th. Now, I've said previously, and they did this in the Mar-a-Lago documents case, Jack Smith and his team meticulously organized the discovery materials, the evidence, the witness statements, documents, recordings, videos that the prosecution is turning over to Donald Trump's team, the defense. The government has undertaken extensive efforts to prepare and organize discovery in a manner that will assist the defendant in his review of the produced materials. Now, the right to a speedy trial. This trial date of January 2nd is about 5 or 6 months away. It certainly comports with a speedy trial. But Donald Trump has been squawking, and some of his attorneys have been squawking, that the right to a speedy trial is a right that rests only with the defendant, only with the person who's charged, and that's not true. The public has an interest in a speedy trial as well. I'm going to quote one of the cases that they said in here that is just absolutely amazing. At the defendant's initial appearance and in several television interviews, defense counsel has suggested that the Speedy Trial Act is intended only to protect the defendant's rights. Not so. Under both the Sixth Amendment's Speedy Trial Clause and the Speedy Trial Act, separate legislation, the right to a timely trial is vested in the public, not just the defendant. And here they're quoting the state of the United States versus Gambino. The Speedy Trial Act was designed not just to benefit defendants, but also to serve the public interest by, among other things, reducing the defendant's opportunity to commit crimes while on pretrial release. And preventing extended pretrial delay from impairing the deterrent effect of punishment. United States versus Gambino was a mafia case from 1995. I don't know if that's one of the ones that Rudy Giuliani originally prosecuted. It could be, may likely be. But they harp on discovery a lot. Discovery is going to be almost done by August 25th. The government has gone to great lengths to organize the discovery material for the defendant to assist him in his review. These efforts include providing a compilation of certain key items of evidence on which the indictment relies. So they took all of this evidence And they said the indictment relies on these items right here. Pay special attention to these items right here. And identifying material potentially favorable to the defense. So out of all of this evidence, we're relying on this evidence over here. This evidence over here may be helpful to the defendant. The prosecution is not required to do that, any of these things, but they are doing these things to make it easy for the judge. And that, as a practicing trial attorney, is something, my boss has been pounding that in my head for as long as I've known him, for over 20 years. Make it easy on the judge to, make it easy for the judge to agree with what you're asking the judge to do for you and your client. Make it easy for the judge to do that. One of the ways you make it easy for the judge in this case to grant the January 2nd trial date is say, we've done all of the work that they need to do in getting this discovery material organized. We've done all of that. All of that time-consuming work was done by us to make it easy on them, to save them months of time, weeks of time. And the judge would be like, oh, that's great. That was very nice of you. I will grant your request for a January trial date. There was something else I wanted to highlight out of this pleading. Defense counsel claimed both in a media interview and in the initial hearing that the government has been investigating this matter for 3.5 years while the defense is staring at a blank slate. Not only is this claim impossible, as January 6th was 2.5 years ago, but it is also disingenuous. That's the polite way of saying they're lying. The defendant has been aware of and has responded forcefully in opposition to certain relevant information made public through hearings and the report written by the January 6th committee in the House of Representatives. Furthermore, defendant and his counsel have long been aware of details of the government's investigation leading to his indictment, having had first contact with the government in June of 2022. In sum, the defendant has a greater and more detailed understanding of the evidence supporting the charges against him now, at the outset of this criminal case, than most defendants do. And is ably advised by multiple attorneys, including some who have represented him in this matter for the last year. So I told you that that Jack Smith would say that as well, that they're going to be like, yeah, there's some new evidence here that we've uncovered that the January 6th committee didn't have, but the vast majority of the evidence, it came from the January 6th committee, and that's been public for over a year, and those hearings were televised over months. He's been aware of almost every piece of this evidence. So he's not starting with a blank slate at all. And so I don't know when the defense has to file either an opposition or a reply to this document filed by Jack Smith, but I would imagine it would be fairly soon. And if I remember correctly, August 28th is when the court is going to pick the trial date. So stay tuned for that.